Good day, Crime Talk aficionados. We have a great show for you. First, Lori Vallow will be exonerated, according to her. Karen Reed's motions hearings will go on forever. Luigi Mangione has a sex tape. The judge in the Bryan Kohberger case wants more transparency. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications, and go check us out on any of your favorite podcasting apps. Now, before we get to the docket, go to crimetalksearch.com. Sign up for that background subscription service today. And when you do, you'll be able to do a background search on anyone here in the United States. And here's the beautiful thing. Whether you want to do one search or 1,000 searches, you can do that while you have that subscription, and you can cancel at any time. And that background report, it's going to have everything you want to know about a particular person. Their social media presence. Are they divorced? Are they married? Do they have liens, judgments against them? Do they have a criminal history? Are they on a public registry? Yes, everything you want to know. So if somebody's coming into your life, or maybe you're thinking, do I need to get them out of my life? Go to crimetalksearch.com and get the information you need to make those important decisions. All right, let's go ahead and get to the docket. First on the docket for March 4th, 2025, Lori Vallow says she's going to be exonerated. That's right. She says she's going to be exonerated, and she's telling her story to Dateline. We get to see it this Friday night. Here's a quick little preview, though. That's right. Now, as you may know, Lori Vallow is behind bars currently in Arizona, specifically Maricopa County, where she is awaiting the trial related to the death of, that's right, husband number 4, Charles Vallow. Husband number 5, the one that got the death penalty, Chad Daybell, is currently on death row there in Idaho. Obviously, both of them were convicted for the death of J.J. Tiley and Chad Daybell's now deceased wife, Tammy. The interview is apparently a little combative, according to insiders who have already seen the video. So that ought to be exciting. But we do see, she says she's going to be exonerated. She says that they both will, referring to Chad. She says, quote, "I have seen things in the future that Jesus showed me when I was in heaven, and we were not in jail, and we were not in prison." End quote. Lori Vallow. Okay, if she was represented by an attorney, file that motion for competency immediately. But since she's her own attorney, I guess she can do that. And guess what? She can do interviews as well. I wonder if that's against her attorney's advice. Oh, that's right. She is her attorney. Anyway, as you may recall, Lori Vallow was sentenced to life in prison back in 2023. The deaths of Joshua J.J. Vallow, Tylee Ryan, and Tammy Daybell. A separate jury found Chad Daybell guilty of all the same crimes, and he got the death penalty. She did not, because there were discovery violations by the prosecution, and she would not waive speedy trial. And therefore, as a sanction against the prosecution, the judge threw out the death penalty, probably knowing she would never face death given her mental inability to remain competent. For example, because she was there for 10 months awaiting trial there in Idaho at the state mental hospital, being restored to competency. Now, this Dateline special is going to include Rexburg Police Detective Ray Hermosillo, Madison County Sheriff Ron Ball, Madison County Prosecutor Rob Wood, and retired FBI Agent Douglas Hart. It ought to be good. We'll be watching it Friday. Will you? Next, the Karen Reed pretrial hearings continue and continue and continue. And what has been resolved? Well, nothing. That's right. So prosecutors on Tuesday argued that lawyers for Karen Reed made, not only in court filings, but in public statements, that they're attempting to poison the jury pool for the second trial that begins next month. Now, the prosecutor, Hank Brennan, made these accusations during arguments on prosecutors' motions to impose sanctions on Reed's defense, which came after lawyers revealed a text message sent by a suspended Massachusetts State Police trooper, Michael Proctor, in a filing that should have been filed under sealed, or at least redacted. Now, the prosecutors have asked the judge to order all defense motions to be filed under seal so that they can't accidentally file those where the public gets to see them. Now, Miss Reed's attorney, David Yannetti, admitted that he violated the protective order and that the message was subject to that protective order issued by the judge, but said that the inclusion of the message and the failure to file it under seal, or impound it is the word they use there in Massachusetts, that it was an unintentional error. Now, when he was arguing to the judge, he said he just didn't connect the dots, so to speak. But then the motion was filed. Then he read the protective order again and then realized, oops, I made a mistake. It was also during this motions hearing today that it was basically revealed, although we had some hint towards it last time, but it was confirmed today that the U.S. prosecutors, the federal prosecutors that were looking into the case, have said that the federal investigation is over and closed. So there'll be no arrests, there'll be no charges from the investigations that were announced at the end of the last trial. Obviously, in some of the recent interviews the defense and the defendant have done in the Karen Reed case have tried to imply that there was police misconduct and that the feds were looking into it, so they will more than likely be charged. Turned out not to be the case. The United States attorney gave Mr. Brennan the permission to state on the record today that that investigation is over, closed, no charges. Now, Mr. Brennan suggested that Reed's defense team was saturating the public with information that will make the jurors' jobs more difficult. In part of the consistent public relations campaign that is sought, he said, it is months before trial, and rather than discuss the facts and litigate facts in part of the jury, it is a deliberate, ongoing strategic investment to reach the potential jury pool. He argued that the ongoing deliberate purpose of poisoning the potential jury pool is not only wrong and unfair, it needs to be stopped. Now, Reed's lawyers also argued 2 expert witnesses hired by the prosecution should not be permitted to testify during the upcoming trial because they lack the qualifications and fail to lay out a methodology in which they came to their conclusion. Now, the experts, James Crosby and Robert Gilman, both did not testify during the first trial. Crosby is an expert in dog behavior who prosecutors intend to have testify about the injuries to Reed's boyfriend, Officer John O'Keefe's arm, while Gilman is a meteorologist who plans to testify about the conditions on the night of O'Keefe's death. Now, Mr. Brennan, the special prosecutor, said he intends to call Crosby only to offer a rebuttal to testimony given by defense expert Dr. Mari Russell, while Gilman will be called as part of the prosecution's case in chief. Russell testified during Reed's first trial that O'Keefe's injuries were likely the result of dog bites. Brennan moved to bar her from the second trial, but the judge ultimately allowed her testimony after a 2-day hearing. Now, Crosby believes that the injuries could not have come from the dog. Reed's defense team has suggested that Mr. O'Keefe was attacked, specifically Chloe, a German Shepherd formerly owned by Brian Albert, whose home O'Keefe was found dying outside of on January 29th of 2022. Now, Special Prosecutor Brennan told the judge that prosecutors located Chloe, who was rehomed in 2022, and Crosby took measurements of her claws and teeth. Those measurements show the wounds on O'Keefe's arm are too far apart to have come from Chloe. But Mr. Robert Alessi, the new defense attorney for Miss Reed, said Crosby failed to lay out the methodology by which he reached that conclusion, not just in a report submitted to the court, but also in his master's and PhD theses that he submitted. Anyway, his methodology is not reliable, the defense argued. He's provided zero, and they mean zero, to tether his methodology to a commonly accepted practice. He doesn't cite to one study. He doesn't cite to one scientific publication that says it is a permissible way to determine whether a bite is from a dog, the defense went on. Alessi also suggested that because Crosby is not a medical doctor, he cannot be permitted to testify as to the medical cause of O'Keefe's wounds. The judge previously ruled that only medical doctors could do so. The prosecutor noted that Crosby had been permitted to testify in a number of previous state and federal cases about dog violence. Russell, on the other hand, had not done so before the Reed case. Now, the qualifications of Dr. Crosby are outstanding and significant. He said he has ample support for his training and experience, and his opinions are soundly based not on hypothetical rhetoric, but on the facts, on the details in the case. He has never changed his position from one event to another. Now, specific then to Gilman, Alessi argued that he should not be allowed to testify about the hardness of the ground outside 34 Fairview Road on the night of Mr. O'Keefe's death. But the prosecutor said he had no need to ask Gilman whether the ground was hard as a rock, as Gilman had concluded, and would limit the questioning on how the ground freezes. Alessi objected to that limitation as well, saying determining how ground freezes requires a specific scientific qualification. This sometimes, ladies and gentlemen, is why things get so weird in court, because no, it doesn't. The jury can use their common sense and say, if the ground was frozen, these people lived there. They know what the ground is like when it's frozen. It gets hard as a rock. You submit the evidence, you argue that fact in closing. Anyway, and as I said, this case has gone on, and these pretrial motions keep going on, and they'll be on again tomorrow, because the judge has yet to make a single ruling on the prosecutor's motion to exclude a pair of accident reconstructionists hired by the federal government for that now closed investigation. And during argument on that motion, the prosecutor revealed that Reed's defense had more communications with the experts than previously known. Now, at the hearing last week that started all this big brouhaha, the judge heard arguments from both sides on how the case should proceed in the wake of those disclosures. Chief among them was that Reed's defense paid nearly a $24,000 bill. During that hearing, Alessi said certain members of the defense team were unaware of the communications at hearings during the first trial. But on Tuesday morning, the judge told the lawyers that when one of them speaks, they speak for the entire Reed defense team, which means if one is going to be sanctioned, they're all going to be sanctioned. Mr. Alessi on the defense side argued that no attorney can be responsible for the misstatements of fact of another attorney unless they have knowledge. Now, a pair of hearings in this case are scheduled for Wednesday, one in federal court, where Reed has asked the United States District Court judge to dismiss 2 of the 3 charges she faces on double jeopardy grounds, and another in state court where the judge will hear arguments on a number of issues, including Reed's motion to dismiss the entire case for extraordinary governmental misconduct. Just a prediction. I don't even need the magic 8-ball for this. Will her habeas petition be denied in federal court? Yes. Will this case be dismissed for extraordinary governmental misconduct? No. And if you're wrong, I know you all will let me know. I'm just making my prediction. Listen, Reed's double jeopardy argument is based upon communications between the jurors from her first trial and her lawyers, where jurors said they agreed to acquit Miss Reed on the charges of second-degree murder and leaving the scene of an accident causing injury or death. The judge and later the Supreme Judicial Court, like the Supreme Court there in Massachusetts, had also rejected that argument. Now, for those who don't know, Miss Reed is accused of intentionally striking her then boyfriend, Mr. O'Keefe, with her car and leaving him to die in the snow outside a Canton home back in January of 2022. Her lawyers say that she's been framed and that O'Keefe was fatally beaten by his friends inside a home and possibly had the dog attack him as well. And then they conspired to put his body outside in the frozen cold, all to frame Karen Reed for the murder of John O'Keefe. Let me know what you think. It's going to get interesting. This judge there in Massachusetts, I think she is becoming the Judge Alito, the 1990s when we had the Judge Alito in the trial of O.J. Simpson. He could never make a decision. We just had more and more hearings, and it just went on and on and on. Maybe a little far in time for a lot of people to remember, but I remember the O.J. Simpson case was supposed to take a week, and it went like 9 months. Any other jurisdiction you'd have this knocked out in an afternoon, and the trial would take 1 week, maybe 7 days, 7 trial days. Next, Luigi Mangione apparently has a sex tape, ladies. That's right. Luigi Mangione allegedly made upwards of 20 highly stylized sex tapes before he was arrested on those charges of shooting the CEO in New York City. The young Ivy League graduate has quite a fan base, and women are reportedly throwing themselves at him as he faces charges for shooting the United Healthcare CEO Brian Thompson. Now, an insider has made some statements to an online publication that Mangione's life before prison, well, it's quite revealing that there are at least 20 videos of him having sex that he filmed and wanted to be watched. It wasn't just some grainy late night mistake. Apparently, it had to be perfect lighting. Apparently, he's a perfectionist, ladies. Apparently, he's a perfectionist. Anyway, he wanted to be watched. He got off on it. This insider is telling the online publication. And apparently, like I said, there's at least 20 videos. If somebody has one of those videos, not that I want to watch it, but, we'd probably pay some money for it. I don't know. I don't think that's wrong. I think he's an adult. And then we could put it out there for the world to see. Just throwing that out there. All right. Anyway, the person went on to say that a lot of girls are a little afraid to come forward and tell anyone for fear that they might somehow get dragged into this case. I don't know. What do you say for that? I don't know. And I'm just joking about we would not want to buy anything. Okay. That's the way people think these days. For those who don't know, obviously Mangione is the subject of a big manhunt after the CEO, Mr. Thompson, was shot dead on the streets of Manhattan there on December 4th. Obviously, we give Luigi Mangione the presumption of innocence, not only in his federal case, but his New York State case for homicide and his case in Pennsylvania as well. We'll see how that turns out. Next, the Bryan Kohberger case. The judge wants more transparency. And, like I said, I'd like to just go to the order. So let's just read the order from the judge in this particular case. All right. Apparently, this judge kind of believes what I believe. It should be open to the public. So let's read the order. The parties' pervasive practice of filing material under seal in this case has become the norm rather than the exception. Rather than seeking to redact discrete, sensitive information, entire documents are filed under seal. In addition, much of the material the parties seek to seal is already in the public domain or simply not confidential or sensitive. This approach runs counter to the public's First Amendment right to know what is going on in the courts. Thank you very much. What have I been saying all this time? This is what happens when you let them file stuff under seal, under the guise of somehow it's going to taint the jury. Anyway, the judge goes on. Consequently, the court will look with scrutiny on requests to seal documents simply because they purportedly contain facts that are not public, that nonetheless will likely come into evidence. The Idaho Supreme Court adopted the Idaho Court Rule 32 to define when public access to judicial records may be denied, including through the redaction and the sealing court records. To warrant sealing or redaction, the material must meet specific criteria set forth in 32I so as to allow the court to make the finding necessary justifying its decision to withdraw the material from the public purview. Moving forward, the court will require the parties to adhere closely to the rule and only seek to seal and or redact materials as provided thereunder. In addition, all proposed orders to seal or redact must specify the basis under Rule 32I3A for which the sealing or redaction is warranted. A bare citation to the rule or conclusory summary without an individualized, rigorous, factual, and legal analysis of the basis for seeking to have the document sealed will result in the rejection of the request. Further, the parties must also seek the least restrictive method to protect information that should be or is exempt from disclosure. For example, despite the court's concern being expressed previously, the state continues to seek broad orders sealing entire documents to protect the identity of individuals rather than simply using initials, or requesting that a redacted version be made public that disclosures only initials. Accordingly, the state's request to seal filings writ whole are denied, except as otherwise noted regarding the certain exhibits containing grand jury testimony or other exempt records. Rather, those filings have been redacted by the court to refer to certain individuals by initials or family members of the deceased victims by their name by the nature of the relationship, e.g., brother, rather than by name. The original filing will be sealed and redacted versions will be made public. In addition, the court has redacted portions of defendants' filings that contain grand jury testimony. Signed, Stephen Hippler. Finally, somebody gets it. We ran into this in the Lori Vallow case. We ran into this to the Chad Daybell case, that they were just doing these blanket orders to seal when they shouldn't or should not be. And once again, we started this in the Kohberger case. The public has the right to know. That's what I've been saying all along. And the judge cited that. And not only did he cite that, he also cited case law from Idaho, State v. Clapp, 479 P. 3rd, 460, 463, Court of Appeals, 2020, clearly shows that sealing of documents needs to be limited and it needs to be clearly articulated as the basis of that. So what does that mean? I think we're going to get a lot more information here real quick, ladies and gentlemen. And frankly, I blame the attorneys for abusing this. Sounds like both sides have been doing it, which I've been complaining about since day one. And the previous judge, who seemed like a very pleasant man, a nice man, a man who wanted to do the right thing, I think was totally overtaken by the publicity of this particular case. Judge Hippler, on the other hand, is like, we're going to get this done. It's just another case. Let's get this case moving. Thank goodness. Thank you, Judge Hippler, for protecting the courts and the Constitution, because it matters. The First Amendment matters, and the public has a right to know what's going on in the courts. If somebody's getting railroaded, we should know. If the prosecution is incompetent, we should know. If the defense is incompetent, we should know. And the only way you do that is for the public to see it all. Thank Judge Hippler, ladies and gentlemen. Big shout out to him. The Constitution matters. Next on the docket, this day in legal history. And on this day in 1789, ladies and gentlemen, March 4th, 1789, the United States Constitution officially became the law of the land as the first federal Congress convened in New York City. Obviously, this marked the establishment of the current framework of the United States federal government, laying the foundation for American law and governments. And don't forget, those Bill of Rights were ratified, the restrictions on the government. Because really, if you really read the Constitution, you would know that the Fed should obviously deal with security, raise armies and navies, interstate commerce, and borders. That's what the job of the federal government was originally intended to do. And it's outlined in the document, as well as the limitations of it. The government was supposed to have a very, very limited role in government. Everything was reserved to the states. If not specifically mentioned therein, all those rights are reserved to the states. And the government's job was to protect the rights of the citizens, not to take them away, unless, of course, you've earned it through some sort of criminal conduct. All right. In 1791, the first U.S. Internal Revenue Act was enacted. That's right. Congress passed the first Internal Revenue Law, imposing excise taxes on distilled spirits to fund the national debt. Obviously, this act led to the Whiskey Rebellion, testing federal authority to levy and collect taxes. On this date in 1865, Abraham Lincoln was sworn in for his second inauguration. That's right. He was inaugurated for his second term, delivering a speech promoting the healing and the unity, the post-Civil War. Obviously, the address emphasized reconciliation and set the tone for the Reconstruction efforts. And unfortunately, all we know that did not last very long, where he was, obviously assassinated. And on this date, March 4th, 1964, Jimmy Hoffa was convicted of jury tampering. That's right. Teamster president Jimmy Hoffa was found guilty by a federal jury in Chattanooga, Tennessee, on 2 counts of jury tampering that happened in 1962. Now, the conviction was the first after 4 previous trials on other federal charges that had ended in an acquittal for Mr. Hoffa. And on this date, on March 4th, 1909, the Copyright Act became law, making infringement of a copyright a federal crime for the first time. And finally, our dumb criminal of the day. A man was arrested for the road rage shooting and charged with aggravated assault with a deadly weapon. Is there any other kind? Anyway, fortunately, no other vehicles were involved in the incident. However, a guy by the name of Taryn was already in hot water when he was added to a text thread where he tried to purchase a baby. That's right. The family was discussing a 9-month-old's baptism when the suspect texted, "That's a nice Caucasian baby. How much do you want?" He claimed he was serious and tried to buy the baby for $500,000 in cash or Bitcoin. And when asked about the attempted baby purchase, Taryn told police that he thought the text was spam. Seems kind of dumb that he would actually believe that the text thread was spam. Don't you get those all the time, ladies and gentlemen? No. Anyway, apparently it also led to a little road rage shooting as well. What can you do, ladies and gentlemen? Try not to buy those Caucasian babies for $500,000 in cash or Bitcoin. And then let's try not to get in a road rage shooting with the family text people involved as well. All right, that's all we have for you today. Thanks for watching. We'll see you next time. And remember, just like Judge Hippler says, the Constitution matters.